Welcome to this explainer. You know, if you own rental property here in Sacramento, just trying to keep up with California's shifting regulations can honestly feel like a full-time job, right? Well, today we're going to break down all those highly publicized headlines you've probably seen about California's gas appliance rulings and exactly what they mean for your properties. Let's look at what recent gas appliance rulings actually mean for you. You've likely seen some pretty alarming headlines lately about gas appliance phase-outs. And hey, it's super easy to worry about your bottom line when you see that kind of news. But don't worry, we're here to calmly unpack the facts for real estate investors. We're going to separate the actual reality from all the online noise. The Ninth Circuit Court decision. So to really understand these headlines, we actually have to look south for a minute. In July 2026, a divided Ninth Circuit panel upheld a landmark rule that was passed by Southern California regulators. It survived some pretty major legal challenges and set a massive precedent for building emissions across the state. This rule, it's called SCAQMD Rule 1146.2, targets over 1 million appliances down in Greater Los Angeles. Basically, it requires a gradual phase out of nitrogen oxide, or what we call NOx-emitting appliances. Think things like your standard gas water heaters and boilers, and this happens at the end of their useful lifespan. To put the scale of this into perspective, it aims to improve air quality for a staggering 17 million residents. Regulating appliance emissions versus restricting gas infrastructure. Now, you might be wondering, why did this rule survive when the famous Berkeley gas ban was struck down a while back? Well, it all comes down to the Clean Air Act. Unlike Berkeley, which literally tried to block gas infrastructure via local building codes, this new rule strictly targets the actual emissions. By framing it as pollution control, the rule stands firm. For property owners down in Southern California, this zero-emission standard is already starting to roll out. But here's the key takeaway. Notice that it doesn't force anyone to just rip out a perfectly working heater tomorrow. Nope. Instead, it phases in gradually over the next decade through 2033, based on the appliance type and the building size. Okay, so let's pivot and bring it back home. Because while those legal precedents are definitely important to watch, your day-to-day operations are governed by the local reality right here for Sacramento property owners. Sacramento's 2045 decarbonization goal. Our city certainly has some ambitious climate goals of its own. The City Council recently adopted a strategy to transition existing buildings to all electric by the year 2045. So it's really a long-term roadmap that perfectly aligns with SMUD's big push for 100% carbon-neutral electricity. But honestly, you can breathe a huge sigh of relief right now, because if we look at the City of Sacramento FAQ, it states, the city will not establish mandatory requirements for immediate appliance replacements or building retrofits. They make it absolutely clear. For now, they are heavily relying on incentives, not forced mandates. No new requirements in Sacramento. To put it simply, and this is the big takeaway here, there are no new requirements today. Your existing practices and your current gas appliances remain completely 100% unaffected. Literally nobody is legally requiring you to swap your gas boiler for an electric one right this second. But you know, there's always a catch, right? Let's talk about the hidden costs of transitioning. Even without an immediate mandate breathing down your neck, aging building systems eventually die out and require replacement. And replacing them with electric? It isn't a simple plug-and-play situation anymore. Upgrading often requires really costly electrical panel upgrades, extra wiring, and totally different spatial and ventilation needs. It basically turns a quick swap into a major infrastructure project. Reactive emergency replacement versus proactive capital planning. This brings us to a really crucial shift in property management. Think about it. Waiting for a heater to completely break down in the dead of winter, that leaves you super vulnerable to sudden, massive retrofit costs. Proactive planning, on the other hand, keeps you in total financial control. This is exactly where strategic asset management comes in. By planning ahead, you dramatically reduce unexpected costs and really protect your long-term investments. Plus, acting proactively lets you leverage generous local SMUD rebates and federal tax credits early while they're actually still available to grab. Legacy property management. Ultimately, successful rental ownership means staying informed and always looking a few steps ahead. But you shouldn't have to navigate these complex regulatory shifts all by yourself. That's exactly why Legacy Property Management actively coordinates your maintenance planning and monitors all these shifts on your behalf. You can learn more over at www.rentlegacy.com to ensure your portfolio is always optimized. We're going to leave you with this final thought to consider for your own portfolio. As the market slowly but inevitably shifts toward a zero-emission future, is your capital replacement plan truly ready for the electric future? Start planning today so you just aren't caught off guard tomorrow. Thanks so much for joining us for this explainer, and we'll catch you next time.